Good evening, everyone. My name is Jim Wabandato. I'm a program officer at the Indian Land Tenure Foundation. The purpose of our event tonight is to help address questions or issues that come up in your own land ownership and land management. The town hall format is designed to revolve around questions and answers. And tonight, our topic is going to cover realty basics. We'll kind of jump around a little bit because with Sarah and I, we kind of cover a lot of these things, and we want to make sure that we're addressing it in a way that's valuable to you. So if you have specific questions, throw them in the chat feature and I will work toward addressing them. And then ultimately, we'll have enough questions to keep us moving along. But this is your session, so please take advantage of the knowledge that Sarah brings to our conversation tonight. Instead of fumbling through an introduction, if you'd go ahead and introduce yourself, Sarah, I would greatly appreciate it, as would the audience.
Sure. Thanks, Jim. Good afternoon or good evening, I guess, everyone. My name is Sarah Rubidoux Lawson. I'm an attorney with Schwabe, Williamson, and Wyatt based out of Seattle, Washington. I focus my practice on tribal law and federal Indian law, and have sort of a niche expertise in issues involving Indian trust land, including leases, rights of way, and some fee to trust. I've lived sort of all over. I've been in Arizona, school in Wisconsin, went to school in Michigan, like Jim. Jim is a fellow Michigan Wolverine, like I am. And I'm an enrolled citizen of the Iowa tribe of Kansas and Nebraska. And I do need to give my disclaimer here. So even though I'm an attorney, this broadcast does not create an attorney-client relationship. I am a lawyer, but I'm not your lawyer. Nothing I say here is legal advice. And with that, we can carry on.
That's a good point, Sarah. I don't think we cover that often enough, but it's critical that this is for information. And if you have a specific legal issue that you would like to have addressed, you would need to seek appropriate counsel and establish a very clear line with that attorney-client relationship. Without, what is the term that attorneys use? The agency. Without agency, it's not specific to your circumstances. So having said that, why don't we go ahead and jump in? I usually try to navigate from some of the core issues and move our way closer toward the more difficult to understand or more common topics that come up. Because we're covering realty, I'd probably say let's start with property. What is trust? What is restricted fee? I don't know, but are you familiar, or do you use bundle of rights very often?
Yeah, the bundle of sticks analogy from law school. Yeah, so I'll start off by saying that you know, our U.S. property system is based in principles that were developed in England, that were brought over by the English and implemented here in the United States. So, you know, one term that we hear in Indian country quite a bit is restricted fee, but it's the fee part that I want to kind of focus on. So the word fee comes from the term fee simple, which is a property term that describes ownership of property. So if you own a house, you probably own it in fee simple. Restricted fee, which is a term, obviously, like I said, that we hear in Indian country often. Restricted fee just means that it just refers to the way that the title is held. So the deed in a restricted fee property says that, you know, this property is owned by Sarah Lawson, subject to restrictions against alienation, and those restrictions are held by the United States government. So I own the fee simple, but it's subject to restrictions. So if we want to talk about the sticks in the bundle, fee simple means you own all the sticks in the bundle usually. Restricted fee means that, you know what, I'm going to grab, that was a really lovely shot of my face, but I'm going to grab my pen's here, right? Restricted fee means that we've removed this one stick in the bundle that says that I have the right to transfer my property freely. By taking away this stick, I've given it to the federal government, or the government has held on to it in this particular case. And the government has said, we're going to hold on to this stick. You can do whatever you want with the property, but you can't sell it or transfer it without our permission.
Let me kind of pause real quick, if I may, because
Sure.
Sarah and I, again, use these regular. The bundle of rights are the right of possession, the right of control, the right of enjoyment, the right to exclusion, and the right of disposition. Just so that folks have it. And I will post a PowerPoint that will share some of the definitions that go with those terms in just a moment.
And so you can pull apart any of those rights and transfer them to someone else. You can lease them to someone else. So right to use is a lease, right? So you're just giving someone the right to use your property. An easement is the right to cross or perhaps use the property for a particular purpose. Easement and right of way are kind of the same thing. They're both the right to cross or the right to sometimes use the property for a particular purpose or not use the property for a particular purpose. So a conservation easement, for example, would be a prohibition against using property for a certain purpose. And the rights to develop, for example, would be held by somebody else. But you can take any one of these rights apart and transfer them to someone else. So mineral rights, if you own fee simple, the mineral rights might be one of the sticks in the bundle, and you can sell the mineral rights or lease the mineral rights to somebody else. The air above, so airspace rights, you can remove the airspace rights stick from the bundle and transfer it to someone else. So for example, near where I live, the major airport has an airspace easement over a lot of the properties that are near the airport that basically gives the airport the right to conduct air traffic. So they've bought one of the sticks in the bundle from all the underlying or all the lower property owners to have these airspace rights. So that's what fee simple means. Restricted fee means that, again, one of the sticks has been held in this case by the federal government. So the federal government owned all the sticks. They transferred most of the sticks to me and have said, okay, Sarah, you get the right to use the property, but when you want to sell it or transfer it, you have to come back to the federal government for permission. That's slightly different than trust land, where Indian trust land, again, it goes back to the title or the deed. And the language on the deed says that the fee simple is owned by the United States in trust for Sarah Lawson. So the United States still owns all the sticks in the bundle, and they're supposed to hold and manage these sticks for my benefit. And so that's the difference between trust and restricted fee and then fee simple. So we'll hear sometimes about restricted fee lands within the boundaries of the reservation or fee simple lands within the boundaries of the reservation. And those are two different things. And Jim, you're on mute.
I am on mute, so my clickety clack of the keyboard doesn't interfere. Can you talk a little bit about what public domain is? And one of our questions in the registration process was, how do tribes preserve commonly owned shared lands not owned by any single individual tribe? So it's kind of a two-part. Can you talk a little bit about public domain lands and how do tribes address, joint ownership within the public domain system?
So I don't have a ton of experience actually with public domain lands or with tribal ownership of public domain lands, I should say. I'm familiar with public domain allotments, and I don't know if those are very commonplace in the United States. I know that we have them throughout the Northwest, but a public domain allotment is where a tribal member applied for an allotment that was perhaps outside the boundaries of any reservation. And it was meant to sort of just provide a homestead for that particular tribal member. And so these are allotments of lands that were out in the public domain. They were federal lands. that the federal government then transferred to an individual. So I know that we have, out where I am, there is a public domain allotment out by where the Snoqualmie tribe is, that is owned in trust for the benefit of, the descendants of one particular Snoqualmie tribal member, but it is outside the boundaries of the reservation and the tribe doesn't have really any jurisdiction over it. Same thing with another public domain allotment that is down, I believe, near Chehalis in Washington, where it is outside the boundaries of the reservation. It was given to a Chehalis Indian over 100 years ago, and it's now owned in fractionated interests by lots of different people, but it is not within the boundaries of any reservation, and therefore the tribe doesn't necessarily have jurisdiction over that parcel in the same way that they would have jurisdiction over properties that are wholly within the boundaries of the reservation.
Okay. Kind of branching from that, can you address the trust or the fiduciary relationship a little bit, whether it be through case law, or legislative law, excuse me, or executive regulation or policy? And again, you could talk about each of those probably for about 30 minutes each. So I guess, what are some of the more important aspects to understand within case, legislative, and executive power when it comes to that trust relationship?
Yeah, so the trust relationship really kind of stems from language that was contained in a court case, one of the cases in the Marshall Trilogy, which the Marshall Trilogy was 3 cases that occurred between, I think, 1828 and 1832. And that's Johnson v. McIntosh, Cherokee Nation versus Georgia, and Worcester versus Georgia. I feel like this is a test. I don't remember which one it was in. I think it's Cherokee Nation versus Georgia, but don't quote me on that. Again, none of this is legal advice. But in one of the 3 cases, Chief Justice John Marshall said that the relationship of the United States to Indians is that of a ward to their guardian. Flash forward over 100 years later to the 1970s, a case called U.S. versus Mitchell, where the case was made that the federal government has this trust relationship with tribes. They have a fiduciary relationship so that they have to manage Indian affairs as a guardian would towards their ward.
Sarah's colleague there is needing a little attention.
My co-counsel doesn't like my explanation. So in U.S. versus Mitchell, the court said, yes, there is this fiduciary trust relationship where the United States is supposed to be acting in the best interest of Indian tribes or tribal members. And they looked at sort of the whole history of the relationship between, going all the way back to that case that I mentioned, saying, this is the position that the U.S. has put themselves in through time. So even though the United States was arguing that they didn't have this fiduciary trust relationship, the way that the United States had acted over the 100 years prior, the court said, yes, there is this fiduciary trust relationship. And so the United States has an obligation to act in either the tribe or the individual tribal member's best interests at all times. And where you really see this come up, or where we saw this come up in the last 20 years, was with the Cobell litigation. So Cobell versus whoever was the Secretary of the Department of Interior, because the case went on for 15 years. But I think it started out as Cobell versus Babbitt.
That's what I'm thinking.
Where, yeah, I think it was 98, so I think that's Bruce Babbitt. Where Eloise Cobell, who is an individual tribal, an individual tribal member from, I believe, the Blackfeet Nation, wanted an accounting for her Indian trust lands, and the Bureau of Indian Affairs, who is the fiduciary trustee who has been managing the leases on her trust land and collecting the rentals from the trust land and paying her out from the rentals that were collected, was supposed to have that information. And that case ran for over 15 years, was finally settled in 2013. But the court found over and over that there is a fiduciary trust relationship. And in that particular case, the United States had not lived up to its trust relationship. So it had failed to do even proper accounting for the monies that were coming in on these leases on Indian trust land. And it could have been grazing leases, it could have been mining leases, it could have been just surface use leases like, a home or something like that. But whatever the use was, the Bureau of Indian Affairs had not properly managed the leases so that the Indian landowners were receiving the most amount of rent. They also had not properly accounted for the funds that came in and could not account for why people were getting the amount of rentals that they were receiving. So that, I guess, gives you a little bit of an idea of how this relationship is supposed to work. It also kind of comes out in what we call tribal consultation. So before the federal government takes any action that affects an Indian tribe, they're supposed to consult with the tribe because, again, they're supposed to act in the best interest of tribes. And the best way to act in their best interest is to ask them what they would like to have done in a particular situation, right? So there are several executive orders and decrees from the federal government that apply to all federal agencies in the executive branch that say that federal agencies are supposed to conduct tribal consultation whenever the interests of an Indian tribe are impacted by some federal action, because the federal government stands in this trustee relationship with Indian tribes.
Thank you. And so with the consultation, I guess a good chunk of our audience that I'm trying to reach with these events is our individual landowners. How would an individual landowner participate? Or does the federal government make an earnest effort to reach landowners to find out some of these issues?
No, not in my experience. So they do consultation with tribal governments, government to government consultation. But I don't know that I've ever seen them expressly reach out to individual Indian landowners for their input or opinion on certain things. And with that, I'm thinking of, when they've done the American Indian Probate Reform Act, I didn't really see a whole lot of tribal consultation that was directed at individuals who had been through the Indian probate process. Same thing with leases. When they rewrote the leasing regulations in 2013, I didn't see a whole lot. There were tribal consultations that were held, but there wasn't a lot of individual Indian landowner outreach or input.
Okay, and I don't mean to suggest that there are not opportunities for landowners to participate in this process. Something that Sarah and I come across often are publication in the federal record. No, was it say federal record? What is it? That's the
Federal Register.
Register. Thank you. The right word. And so there are opportunities for individuals to learn that there are issues that are going to affect Indian land through the Federal Register, and it will suggest what the feds are thinking of doing, what they might want to do. And it does allow for individual public comment. And so if you reach out to the Indian Land Tenure Foundation, we may be able to suggest how to participate through Federal Register, but the topics are individualized. And so it would be impossible for us to make sure that everyone knows. Do you have recommendations on how folks might learn when some of these issues come up? You're on mute.
I just saw that.
Yep.
I don't really know off the top of my head. I think that the direction I would look is obviously, getting involved at the Indian Land Tenure Foundation, because, based on your name, you are interested in, maintaining tribal ownership and individual ownership of Indian lands. Another option would be to, if you are a member of a tribe that has a land office or a real estate office, touching base with them and asking, hey, have there, can you let me know if anything comes up for a tribal consultation on this topic? I don't really.
No, that's okay.
I don't really know other than that. So, I mean,
No.
letters go out to all the tribal leaders when there's tribal consultation for example, regulations that come out in the Federal Register. But I don't know how, the average Indian landowner is going to be able to access that information.
Okay. So it sounds like they might need to organize a little bit and, lean on resources like the Indian Land Tenure Foundation to find out, I guess, if there's anything going on. We'll generally catch wind of it. One of the reasons that I decided to look at kind of refreshing the Realty basics was a question that came in regard to undivided interest. And so that kind of fills in a few different things: undivided interest, fractional ownership, equivalent acres. Kind of what is your experience in dealing with that? I guess I often talk about compare it to corporate ownership, but I don't know that necessarily hits home for a lot of folks. Do you have a way that you've been able to effectively communicate those issues?
Well, I don't know if I've come up with a way to effectively communicate them, but I'll tell you how I describe it to people.
Mm-hmm.
And so fractionated ownership, especially if you're an Indian landowner on the call, I'm sure you're experienced with that. So fractionated ownership just means that all of the people on this particular allotment, for example, own a fractional interest in the property. So no one person owns 100% of the property. They all own an interest. It kind of is like, in my sticks in the bundle, you have maybe the pen point of all the sticks, but you don't have all of the stick itself. Like you might have the pen cap, but not the entire stick. So a fractionated interest just means that you are what we call a tenant in common with all of the other owners. Tenant in common is, again, one of our words that goes back to jolly old England that came over, and a tenant in common just means that, again, you own with a number of other people, any number of other people, and that you all have the same rights to the property. Undivided just means that you all own rights to the whole. So you don't have a particular piece of the allotment that you own. You have rights to the whole allotment. Where this becomes problematic, obviously, is when you have highly fractionated allotments, and the definition of a highly fractionated allotment is any allotment that has 20 or more co-owners. So in a highly fractionated allotment, where you have 20 or more co-owners who are all tenants in common, so they all have the same rights of an undivided interest, so they all own the whole property, and sometimes it's families get into a fight and they want to kick one family off the allotment or something like that. Well, that can't really happen when you have tenants in common, right? They all have a right to be there. It's interesting, in Indian country though, we have this layer of federal ownership. So again, while we are tenants in common of undivided fractionated interest, we don't own the fee. We don't own the fee simple interest in the property that's held by the federal government when we're talking about trust lands. And so we have this federal layer of regulation that then says, okay, here's how we're going to deal with relationships among tenants in common. And so this is where you end up with things like, the leasing, the regulations for leases of trust land for residential purposes. Say things like, if an owner's lived on the property for, I think it was more than 7 years as of January 1st, 2013, then they don't need to have a lease, right? But at the base, the federal government regulations say that anyone who wants to use the property, whether you are an undivided tenant in common with your other fractionated owners, anyone has to have a lease to use Indian land. And that, I think, just goes to trying to I don't want to say regulate the relationships, but trying to manage the relationships amongst co-owners of Indian land, saying no one has the right to any one piece. The only thing that will give anyone rights to any one piece is obtaining a lease.
So if I have a 5% interest in an 80-acre parcel, there isn't any, I can't go to 4 acres and say, this is where I'm going to build my house. Is that kind of what you're getting at?
Yeah, that's correct. Yeah, you can't just pick out any 4 acres and say, okay, this is mine, because everyone else has the right to that same 4 acres. The only thing that would give you the right to, the way I describe it, is the right to exclude any of your co-owners from that 4 acre parcel would be the lease. The lease would be those other co-owners saying, yes, we are going to give you the exclusive use rights for that 4 acre piece. And we're going to say we don't have the right to use that 4 acre piece.
So even though it's I have ownership in the land, why would I need to have a lease then? You talked about exclusion, but I'm purposely being obtuse, but
Yeah.
why is it important to, what does that do for me as an individual then? I hear you talk about exclusionary, giving me rights. Are there other valuable reasons to have that lease in place?
Well, I think it would be those exclusionary rights, right? So if you had a home on the property without a lease, then theoretically, any other co-owner on the property could also lay claim to that home and just walk right through the front door. Where if you have this sort of exclusionary right, then those landowners have already given you permission to exclude them from that property. And again, this is not so say it's Sarah Lawson that says you have to have a lease. It's the federal regulations. Uncle Sam has said, Uncle Sam, who remember, owns the fee simple interest, regardless of whether your property is in trust or restricted fee. They have the rights, the United States government owns the rights against transfer of the interest or use of the interest.
So if I wanted to lease my land, would I be able to do that through the tribe, or is that something that goes through the Bureau of Indian Affairs?
That's a good question. So kind of both. Usually the Bureau of Indian Affairs manages all leases and rights of way, and basically has everything to do with any transaction on Indian trust land. A lot of tribes, however, have taken advantage of what's called self-governance or self-determination. So they have contracts or compacts with the Bureau of Indian Affairs to basically do all the BIA work on that reservation. And so sometimes you can go to the tribe's land office and they can help you with doing that work on your allotment with leasing land. But usually it's done through the Bureau of Indian Affairs, and they can assist you with leases on Indian land.
Okay. One of the attendees has a question about partition. Can you describe what a partition is, and how is that a right that an owner has? How might they, begin the process for doing a partition?
Yeah, so under the federal regulations, any Indian landowner can ask to partition their property. And a partition just means that, in that 80-acre parcel, you have the 5% interest, which represents about 4 acres. And so you can go to BIA and say, I want to partition my interest, my 4 acres, off from the rest of the parcel. And you have the right to request that BIA do so. I think the issue that I've run across here with partition is that even though any Indian landowner has a right to request a partition, getting that approved through the Bureau of Indian Affairs can be difficult, especially if you are, only a 5% interest holder of a large allotment. What the BIA likes to see in most partitions that I've been through is they like to see agreement amongst all of the property owners as to the partition. So everyone's agreed that, Johnny gets this 4 acre parcel and Janie gets that 4 acre parcel. And Joe gets this other 4-acre parcel, right? They want to see agreement. They generally don't like to approve a partition without the agreement of, I think, 100% of the landowners as to what piece is being partitioned out and how much is being partitioned out. You know, they also like to see that it's proportional to everyone's interest. So if you only have a 5% interest and you want to partition 50% of the property out, you know, they're not going to allow that to happen as well.
Okay. One last question, and this came from the registration process, and it talked about private property kind of abutting against trust property. So within the reservation, do trust allottees basically have any rights in regard to that? And if they don't, does the tribe have any rights that they might be able to exercise in relation to that fee land that abuts against trust land?
Yeah, so you know, we should go back and say, how did we get here, right? How did we get to what they call checkerboarded reservations? Well, that was under a federal law that was passed in 1887 called the General Allotment Act, also called the Dawes Act, where Congress decided that the solution to the quote unquote Indian problem was to allot out parcels to each individual Indian on the reservation. So the head of household got, I think, 160 acres, and I think women and children got either 40 or 80 acre parcels. But the entire reservation would be allotted out to every tribal member. And their thinking there was, you know, we're going to help assimilate Indians by sort of showing them that, showing them the joys of individual land ownership. So the problem with Indians is that they, again, I'm not saying this was Congress in 1887, right? The problem with Indians is that they hold land communally, and that's just weird. And so, you know, they need to understand the joys of individual land ownership. Part of the other reason why the General Allotment Act was passed was because Congress was looking at these huge tracts of land that had been set aside under these treaties and saying, we have, you know, thousands of acres that are only populated by a few hundred Indians, and we need to be able to unlock these huge tracts of land for settling, for homesteading by our non-Indian immigrants who are coming in and pushing west. And so under the General Allotment Act, after every man, woman, and child received a land allotment, any lands that were left over, which were called surplus lands, any surplus lands could then be sold off to homesteaders. So it was meant to do two things. It was meant to, the law was meant to assimilate Indians and then also break up the reservations so that they could open up more land for settling. See, baby doesn't like it either. So that's how we got to having these pockets, essentially, of fee simple land within reservation borders. These were either properties that were within the reservation that were declared surplus land and then sold to non-Indians in fee simple, or they were allotments that were originally held for a 25-year trust period and then either fell out of trust at the end of the 25-year period or were sold by the individual Indian landowner to a non-Indian, you know, with the permission of the federal government. So we ended up with this, what they call checkerboard pattern of land ownership on the reservation, where you might end up with an Indian trust allotment that's right next door to a non-Indian who owns in fee simple, and that's right next door to a allotment that's still owned in trust for the benefit of the tribe. We have all these different patterns of ownership. When it comes to fee simple parcels that are within the boundaries of the reservation, those parcels can be repurchased either by the tribe or someone who's a tribal member. And then those properties can actually go back into trust, which gives you the benefit of being free from state taxation. So you don't have to pay any state property taxes. And you are free from regulations. So if there's county regulations on, for example, noxious weeds, you would not be subject to those county regulations. There's no right of first refusal usually. So, it doesn't necessarily have to go to the tribe. It can be purchased by any individual landowner and put back into trust. The only hitch there is that you can't, for example, go buy a piece of property within the boundaries of a reservation that's not your reservation. So I'm a member of the Iowa tribe of Kansas and Nebraska. I live in Seattle. So I can't go to the Puyallup reservation. I can't buy property within the boundaries of the Puyallup reservation and have it put into trust unless I get the permission of the Puyallup tribe to do so. So you can't go to another reservation and have land automatically taken into trust unless you get the permission of the tribe.
So you mentioned fee to trust. Is that something that is available to individual Indian landowners? I think most of the time when it gets discussed, it usually revolves around the tribe.
Yeah, so individual landowners can have land taken into trust for their benefit. There are some caveats with that. So individual landowners can only have land taken into trust that is either within the boundaries of the reservation or is what they call adjacent or contiguous to the boundaries of the reservation, which basically just means that it has to share a parcel boundary with the reservation. Unlike tribes can have properties well outside the reservation taken into trust on their behalf. Individual tribal members don't have that option under the federal regulations as they are written today. But you can have land taken into trust as long as it's within the boundaries of the reservation or shares a boundary with the reservation.
Okay, and I do know, I've seen it in action with the fractional ownership. Are you familiar with, and can you discuss a little bit in regard to mandatory acquisition?
Yeah, so a mandatory acquisition there's a few different types of mandatory acquisition. So one is, for example, if there's a congressional act that says that the BIA has to take this particular piece of land in the trust, or when there is a interest in an interest in trust land that has fallen, the interest has fallen out of trust and into fee simple, and the owner then asks to have that interest taken back into trust. So I'll address the first one. So with tribes, there was, excuse me for a moment.
It's okay. So, and we'll kind of come back to this, but the other thing that we'll make sure to address a little bit too as we get past the fee to the trust conversation is that people get frustrated in dealing with the Bureau of Indian Affairs. And so once you wrap this up, could you address a little bit about removing restrictions or taking land out of trust? I know it's controversial, but it is a tool that is available to Indian landowners.
Yeah. So going back to mandatory fee to trust. So one type of mandatory acquisition is where there's a congressional mandate. So for example, there was a tribe that I worked with in Arizona where the federal government had condemned some of their tribal lands in the 1960s under the Central Arizona Water Project. And when they condemned that land, they, paid the tribe a sum of money and said, if this tribe wants to use this sum of money and have land taken into trust on their behalf, they buy new land with that sum. He's just not going to cooperate right now. Okay. If they can have land, let me go back. So Congress said, we're taking this tribe's land, we're going to pay them for it. And if they want to buy a new parcel using this money that we're giving them, then they can automatically, under a mandatory acquisition, have that land taken into trust. And so that one tribe that I work with did so and had that land taken into trust as a mandatory acquisition. The other type of mandatory acquisition is acquisition of a fractional ownership into trust. So prior to the American Indian Probate Reform Act, if an Indian died without a will and they had a non-Indian spouse, the non-Indian spouse would inherit their interest in Indian trust land. But when a non-Indian inherits Indian trust land, their interest, so their 5% interest, for example, falls out of trust. And so you have this property. The land itself is still held in trust by the federal government, but they have this interest in the land, right? So, you know, a pen cap that is held in fee simple, like any other non-Indian would hold land. So in order to get those fee simple interests in land that is already held in trust, get the fee simple interest back into trust, that is also considered a mandatory acquisition. And that's under the, I believe it's the Indian Land Consolidation Act. It's a mandatory acquisition. So if you are an owner of a fee simple interest, you can have the Bureau of Indian Affairs take that interest back into trust on your behalf. And it's theoretically a quicker and cheaper process for you to do that than if you were acquiring a parcel outright and asking the Bureau to take it into trust.
Sure. And I had also talked a little bit about landowners wanting to remove the restrictions. Again, especially when I've talked with farmers and ranchers, they may have 100% ownership of a piece of land, but when they're trying to work with the U.S. Department of Agriculture or even their bank, they're just finding the process to be untenable, and they would like to take it out of trust or take it out of restricted status. How would somebody do that?
Yeah, and so you see that. So for example, when they're working with the bank, they may be working with a bank that's unfamiliar with Indian trust land and doesn't know how to, for example, get a lien or a mortgage against it, which mortgages on Indian trust land can be done if you own 100% of the interest. The mortgage just has to be approved by the Bureau of Indian Affairs. But to take your land out of trust, you just have to apply to the Bureau of Indian Affairs to take your land out of trust. Now, what that means is that you lose some of the benefits associated with that land. So when it's in trust, it is not subject to any, state or local property taxes. So you don't have to pay property taxes on the property. And it's also not subject to state regulation. So, I mentioned noxious weeds ordinances. When it's in trust, it's not subject to those rules. Once it goes out of trust, it's just like any other property within the state or within the county, and it's going to be subject to all those same rules. So you're going to be subject to state taxation. You're going to be subject to, county regulations regarding the use of your land, county zoning, and any other, state or local ordinances that might apply to other properties in your area. So you're just like any other non-Indian who owns land out there. Now, granted, at that point, you're not subject to any federal restrictions anymore either. So you can freely transfer the land. You can easily do a mortgage. You can easily sell. You can easily lease. You just don't have that federal layer of bureaucracy that you have to get through in order to do any of those things.
So have you seen or have you come across court cases that have had tribal members assert that zoning or some of those land use regulations are civil jurisdiction, and as a tribal member living within my boundaries, I should be exempt from that state civil jurisdiction? Have you seen anything like that?
I don't think I've seen it with tribal members in particular. I think that I have seen it with tribes, where tribes own the property in fee simple and it's within the boundaries of their reservation. And I think that the argument is stronger with tribes. But I don't think that I've seen it all with individuals.
Okay. I've got a different kind of question coming in from the audience. Asked about the March 1899 federal law stating that railroads need to pay rent on easements crossing Indian lands. Is that something you're familiar with at all?
So they might be referring to, I think, the 1899 Right-of-Way Act that allowed rights of way in Indian country for railroad purposes. But I have not dealt a lot with that law. In fact, I have never looked it up and couldn't tell you what the statute says. I will say that I have come across, other easement statutes in Indian country that don't seem to be followed very well. So, for example, I think that the oil and gas rights of way statute says that the oil and gas companies have to pay, I want to say it's like $5 a year or something like that to the tribe for use of their lands. And I don't think that that ever happened. So, there are those old right-of-way statutes. I think that there was a total of 7 different rights-of-way statutes that authorized, at first, very explicit uses for rights-of-way in Indian countries. So it started with railroads, then it went to power lines, and finally ended up in 1948 with the general rights-of-way statute, where Congress just said, we're tired of passing these laws that are just limited to this one use, like just limited to oil and gas, just limited to electricity. So we're just going to pass a general rights-of-way statute that allows rights-of-way in Indian country for any purpose.
Okay. Let's see. Looking through my list of questions. I know that one of the more difficult issues, and Bureau of Trust Funds Administration, which was formerly the Office of Special Trustee, has been pretty good in trying to get information out in regard to understanding the forms. So specifically looking at issues like the trust inventories. Have you worked with a lot of trust inventories? And what are some of the experiences you'd like to share with the audience in better using that information?
Yeah, so they've made those more readable, I think, in the last 10 years or so. They're a lot, I think, better organized and give you a bit more information with having to know all the special codes that go along with them. Because there are certain, code numbers that go to different things. But really, I think that there was, a few years ago, an issue of the message runner that was put out by the Indian Land Tenure Foundation that did have a key, basically an answer key for deciphering what all the codes on a title status report or an Indian trust inventory are. And it's really beneficial for landowners to know what the numbers mean. So, for example, you see the number 109 on your report when it regards a track number, and you're like, well, what does 109 mean? Oh, well, 109 is the reservation number. Depending on where that information is located, it can actually be really helpful to have that sort of answer key to help decipher what's in your report. They're also really great too for figuring out what is and is not on title for your property. So there might be a discrepancy between what you see physically on the land and what you see on paper. And a lot of times it's what you see on the land is more than what's actually on paper. So if you go out and do a physical inspection, you'll see power lines and all kinds of other things that are on the property that are not properly recorded on title.
So it sounds like what you're describing is a little bit of the difference between a trust inventory, which you might get on a regular basis as part of your quarterly statement, versus a title status report. Is that correct? And how would somebody get a title status report?
It's another good question. So no, actually what might be on the title status report might be different from what you actually go and do and see in a physical site inspection. So you might see.
But the title status report is supposed to have all of that stuff, is what you're saying.
Yes, yes. So you might see no easements on a title status report, and you go out to the property and you're looking at it going, well, there's a power line crossing the property, and then there's a road crossing the property, and there's all these things that are on the property that are not reflected in the title status report. The way to get a copy of a title status report is to contact your local Bureau of Indian Affairs office. You used to be able to sort of contact the Land Title and Records Office directly to get that information, but they changed the regulations for the Land Title and Records Office, and so now you have to go through BIA. BIA has to request the report for you. But it's really beneficial. If you're an Indian landowner, you can go on your your ITI, your individual trust interest report, and see what properties you own. And then you can also request a title status report for each one of those properties, so you can see how that land is being used if, for example, you live 2,000 miles away. So if I was a fractionated interest owner on my reservation, I would take my ITI and request title status reports for each one of those properties so that I could see what the property is being used for. Is there, a lease on the property for corn or soybeans, right? Or is there a right of way crossing through the property for an oil or gas line?
You had said the regulation was changed so that it pushes it through the Bureau. Does that also limit or stop the Bureau of Trust Funds Administration from providing a TSR?
I don't know if the BTFA, I don't know if it has access to the land records. So what you an ITI, but it would still have to go to the Bureau of Indian Affairs to get.
All right, thank you. As I'm looking at the clock, we've got about 5 more minutes, and I've been pushing a lot your way. Giving you a chance, are there issues for landowners and on basic realty that you come across pretty regular that you want to make sure people understand before we leave this evening? Are there other issues that you want to make sure we get introduced?
Well, so going back to trust, for example, a good note is that it can be an expensive. So there are, to order a report for the property that you own, you may have encumbrances on that title that you'll have to have a national NEPA review, so a National Environmental Policy Act review, as well as a state environmental site assessment property. You'll have to likely have a survey done. And so all those things, and so that's actually a major barrier to individual getting land into trust, is that, getting a phase 1 environmental site assessment and a survey done for the property. And part of the problem with phase 1 site assessment is that it will expire on the 6th. So you get it done to proceed a trust application to the Bureau of Affairs, the Bureau a long time to process it. You could very well issue expires before they get around to reviewing it, and you have to. BI has been trying to work on ways around that to make it less expensive, but they have because they won't take title without knowing conditions. That's been that I've run across. Otherwise, just sort of understanding fractionated tenant in common ownership of your property and what you can and can't with the property with co-tenant. The are with that Sarah layers. So it's not so say it's Sarah Lawson. So say Uncle Sam. He's got a whole book of regulations that say sort of regulations.
Guess one last question, because I've got a couple more minutes. You mentioned tenancy in common a few different times. The American Indian Probate Reform Act, which was passed in 2004, is legally an amendment to the Indian Land Consolidation Act from way back in 1983. But one of the pieces within APRA is the judge using or perhaps forcing joint tenancy with right of survivorship. And folks may not realize what that means. Can you describe that? And also, if family members get stuck with that, is there a way to defeat that under the federal process?
Yeah, so and I think it's not with right survivorship. I think it's just right survivorship, because joint tenancy would say it's a little bit like but it's really for tenants, and each own their own individual interests, but they are all with one another different. the law. But right membership simply means that when, one of the joint tenants, for example, way interest, or own like an outright interest, but fictional interest gets passed automatically to their joint tenant. So, for example, you and I owned property as joint tenants with right ownership, and pass the rights to the property, and you have full rights to the property. Like bank accounts, very frequently with property. So it can be applied to many different areas. The other probate is you see life estates, and life estates weren't done very frequently prior to the American Indian Act. But under that act, if a non-Indian spouse is set to inherit, they don't have interest in land anymore. So the non-Indian spouse was inheriting a trust. Simple. Well, the American Reform Act interest from falling out, it was called a life estate, which means that that spouse gets to use the property as if it was their own, or to use it in their own to their life. But when they pass away, the interest automatically passes to what they call the remaindermen, which is based for their children.
All right. Well, I appreciate your time this evening, everyone, and especially to Sarah for with her co-counsel sharing with us this afternoon information that hopefully will address some of the issues that are frustrating you, perhaps illuminate some of the issues that you might want to take a closer look at. If there's anything that came up during this event, during our conversation tonight, certainly go ahead and let us at the Indian Land Tenure Foundation know, and we can either try to derive a more thorough answer or get you directed to additional resources. Thank you, Sarah.